Durst is present, Mr. DeGuerin, we have Mr. Bailey and Henderson at council table, Mr. McEwen and Mr. Miata nearby, and Mr. Chesnoff is present as well. Our witness, Detective Coulter, has resumed the witness stand. I'll remind you that you are under oath, and Mr. Ray is present also. I see. And Mr. DeGuerin, you may continue with your cross-examination of the witness.
Thank you, Your Honor. Detective Coulter, I want to talk about the scene a little bit. There's no question that before you got to the do your walkthrough at the scene, and after the first detectives had the scene, that people went in and out.
To my knowledge, yes.
In fact, when you got there, when you went for your walkthrough, the back window or the kitchen window was open, wasn't it?
I don't recall it being open at that time. On the 11th?
Yes.
I don't recall it being open, no. Did I have it in my notes?
Yeah.
Show me my notes and maybe it'll refresh me.
I thought I saw it in your notes, but it's not an important point. We can go on. The fact is, it wasn't locked, was it? The house.
Well, it was one of those, what is it, a French window or the little glass kind of, I don't know what you call those little locks or to secure it, just turns downward into like a French door
right.
lock, I guess. I don't know what you call those things.
Big enough for a person to crawl through.
Oh, you could crawl through it, yeah. Maybe not me, but somebody smaller.
Well, at any rate, you would have preferred to have been there right away, wouldn't you?
I'm sorry?
You would have preferred for your investigation for you to have been there right away.
Well, of course. I'd want to be the one doing the initial crime scene, sure.
Okay. If other people had been, and not police officers, not trained officers, if other people had been on the scene, there's always a chance of contamination, isn't there?
Yes.
Always a chance that evidence might be removed.
Yes.
You learned that Mr. Brenner had gone through her desk, right?
I know he had gone through the kitchen window, he told us that.
Well, yeah, getting in, going through the window, but rummaged through her desk.
I'd have to look at his statement. He might have told us that. I don't remember it as I sit here today.
Now, you found several items that you thought were important on the desk, didn't you?
I'm sure I did. I collected several items. I think papers and cards. We were looking for people that maybe we could talk to about her.
Right. You did not collect the box of plain envelopes, did you?
I don't believe I did, no.
And did you collect any postage stamps?
No.
Okay. Or writing materials?
I'm sorry?
Or writing materials such as a pen or pencil or anything?
I don't recall. Could I look at the notes here?
Please do. That's.
I have all the proper reports in one spot.
Well, I'm trying to find one from January 11th to see what I actually collected and booked. Do you have that one handy?
Mr. Bailey, he has asked if you want to show him that.
Actually, I found it. So to answer your question, no, I did not recover any stamps or envelopes.
Okay. Do you remember seeing a box of plain envelopes on the desk?
Not as I sit here today, no.
Okay. by the time you were assigned to the case, you knew about the cadaver note, didn't you?
No, actually, we found that out when, after we did the walkthrough and went to West LA Station, Detective Roberts told me that he had received that note from Beverly Hills PD.
Okay, so you didn't know the significance of a box of plain envelopes on the desk?
Not when we were at the residence initially, no.
All right. You said that you ordered further examination of the house for fingerprints and other things, but let's stick on fingerprints for a moment, right?
Okay.
And you, is that right?
Yes, yes.
And in fact, you mentioned that you wanted to have the ninhydrin process used, which is different from dusting for fingerprints, right?
Right, and anhydrin is a chemical process, and it could actually be cancerous, so you have to seal up the place afterwards and come back in a day or two to see if there's anything developed from it.
Okay. And eventually, there were some fingerprints that were found, right?
Yes.
Meaning not Susan Berman's fingerprints.
Correct, yes.
But they were not Bob Durst's fingerprints, were they?
No, they were not.
They were somebody else's?
Yes.
And who was that person? Do you remember the name?
You know, it was the son of a... Susan Berman had gone to college with this lady who lived up in the Oakland area. Her son was going to attend USC. He came down and lived with Susan Berman for a short time and stayed in that room where her body was eventually found.
So that didn't cause you to focus on that person?
No, we went and interviewed him and talked to him.
Sure. And you were asked on direct examination if your focus was on Bob Durst at that time, and you said no. Right?
No, it wasn't.
In fact, your focus was not on Bob Durst until much later in October of 2001 when you got the call from Cody Caslis, right?
That's right. I mean, Mr. Durst was a person we wanted to talk to, just as we did her other friends and associates, like Mr. Kaufman, Mela Kaufman, Sarah Kaufman.
Al Brenner.
Yeah, there's a few of them. Al Clethen.
He's the comedian?
Richard Markey. There were several people we talked to that were friends of hers.
You mentioned Al Clethen. He's the comedian, the stand-up comedian?
I don't know if he's a comedian or not.
Oh, well, the jury does.
I knew he was going to be a writer or something. She was helping him with his writing.
Okay. So, you did have information before October of 2001. You did have information that Bob Durst was a close friend of Susan Berman, right?
Yes.
Everybody said that.
Yes.
That they were like brother and sister.
Yes.
And yet your focus was not on him until the call from Cody Caslis.
Right.
Right. Now, you interviewed a number of people early on. Let me just read a list of some of the more significant ones.
There's a lot of people.
Niall Brenner.
Niall Brenner, her manager, yeah.
Paul Kaufman.
Or I don't know, common law, I guess you'd call him.
Yeah, and he was reluctant at first. I think you said you had some trouble setting up an interview?
He wasn't the most cooperative, but I mean, once we finally got him, he sat down and talked with us.
And Sarah Kaufman, his son.
Sarah, yes.
Richard Markey, of course, who had seen Susan.
He was with her the night before at the movies.
Right. Mela Kaufman.
The play daughter. She was up in Portland, Oregon.
Right. And Lorraine Newman.
Lorraine Newman, yes.
And that's not an exhaustive list. I understand it's not. there were a number of other people that you interviewed, right?
Quite a few other people.
Paul Kaufman, though, as you've testified and as we went into shortly before cross-examination, said something to the effect that, well, let me get it right. Your interview of him, Paul Kaufman, was in March of 2001, March 27th to be exact, right?
Correct.
Most of your other interviews had been earlier than that, hadn't they?
Some of them had, yes.
And was the reason that you didn't get around to him until March partly because of his resistance?
No, I wouldn't say it was because of his resistance. It was just that you interview people, you pick up other cases, you interview people. That's when we got around to interviewing him in March.
But he
So
still...
that's what, 2.5 months later?
Sure.
Right.
But still, he did resist, and it took you a while.
Well, you say resist. I mean, it wasn't like a physical resistance. He was always like avoidance, I guess I would call it. More
Okay.
avoidance.
So he avoided you at first.
I think so. I would say so, yes.
And so what I want to ask you about is, in March of '01, he told you that at one point Susan had said, or told him, that Bobby Durst had killed his wife. Now, the reason I'm asking you this is because I want to focus on your focus not being on Bob Durst as a suspect for Susan Berman's killing. That's what he told you in March, right?
Mm-hmm.
And yet, as you have to verbalize your answer.
Well, I
You-
didn't know that
you,
was a
you said-
question. You're making a statement, and
Well, no,
Go ahead.
I'm making it a question. I'm putting a question mark at the end of it. So the question is, that's what Kaufman told you in March, right?
okay, yes.
And yet still your focus was not on Durst until October.
My focus was not on Durst in regards to the murder of Susan Berman at that time. Now, I was in touch with New York authorities, so whether I passed that information on to Joe Becerra at that time, just as I passed some information on to Cody Caslis afterwards, based on interviews in LA later on. I mean, I was in touch, but as far as the Susan Berman murder, we were not focusing on Robert Durst at that time.
Yes, and that was my question, and I want to continue with that
Okay.
and ask you more about the Kaufman, and I'm saying Kaufman. You say Kaufman or Kaufman?
I don't know. I say Kaufman, you say Kaufman. Whatever. We know who we're talking about.
It's tomatoes and tomatoes, I guess.
Yeah, that's right.
All right, so he also said, though, that he was unsure, but he thinks that Berman had told him that Durst had made this admission. That's in your report. Is that right?
Well, yes, it is.
Okay.
Let me read.
So, I want to ask you about that conversation. Did he tell you that
Can I clarify that? It's not that he's unsure that she said it, but that he's unsure if Durst had made that admission to her or if she knew another way.
okay,
Does that make sense?
sure, it would be completely different if Durst had said that to her than if she knew it from some other source, right?
Exactly.
Or believed it from some other source.
Okay.
But you interviewed a lot of people that told you that that Susan didn't believe that Bobby was guilty of that murder or that disappearance, right?
That's gonna call for hearsay, it's all.
Just say hearsay. Not that is going to call for hearsay. Say, objection, hearsay. Sustain.
I heard you the first time, Judge.
All right.
Okay, but that's what you put there, and that's what Kaufman said to you. He's unsure, but he thinks Berman had told him that Durst had made the submission to her, but he's unsure, right?
Is that a question again?
Is that, yeah, right.
That's what it says, yes.
Objection, misstates testimony.
I'm sorry, just a moment. I've lost it. Restate your question, please.
Okay, I'll do that. Quoting now from your report. Kaufman is unsure, but he thinks Berman had told him that Durst had made this admission to her. Period. End quote. Did I read it correctly?
Yes.
All right. And so Kaufman was unsure about what he was telling you, right?
That's not how I understood it.
Okay.
The way
Well,
I understood it is he was unsure as how she knew that,
or thought she knew that.
or thought she knew that, however you want to.
Okay. Well, did Mr. Kaufman tell you that that he and Susan Berman were sharing story ideas on a plane trip to New York?
You got to direct me to that. I don't recall that.
It's not in your report. I'm asking you whether that was part of what Kaufman told you.
I don't recall that now.
All right. You know from you've been in Los Angeles a long time, and you know the movie business and writers and script stuff, don't you?
Do I know writers and script stuff?
Well, let
Try
me.
not to deal with them. No offense. But
Okay.
if there's any
Well,
here.
would you agree that as a detective in Los Angeles, the home of Hollywood, that you're more likely to be familiar with the way writers work than some country boy from Texas?
Hey, I'm just a city boy from Venice. No, I don't deal with Hollywood people.
All right.
So
Well,
not if I don't have to.
so the question is, if you remember, whether Kaufman said to you, as he said here, that they were trading story ideas on an airplane flight to New York when whatever statement she made was made to him. It's not
No,
in your...
As I sit here, no, I do not remember that.
Okay.
Try to look at my notes.
And would it surprise you that he would say that that's the one and only time that she said anything about it and he didn't know whether she was serious or not?
Wait, repeat that again?
Yeah. Would it surprise you to know that he said that's the one and only time she said anything like that and that he wasn't sure if she was serious or not?
I don't know. I don't know what's in his mind.
Okay. But at any rate, we'll get away from Mr. Kaufman as soon as I ask this. Even though Mr. Kaufman told you that in March, your focus on Bob Durst, your focus was not on Bob Durst as a suspect in the killing of Susan Berman until October. Is that right?
That's right.
Okay. Now, that changed in October of 2001 when you got the call from Cody Caslis that Bob Durst had been arrested for murder, right?
That's correct, yes.
You made a trip pretty quickly after that to Galveston, didn't you?
Yes, I don't remember how many days after that. Could have been within a day or 2, 3, somewhere in there. We did go there to Galveston, yes.
And what you learned is that when Mr. Durst was arrested, he had in his possession a 9mm semi-automatic gun, right?
That's correct, yes.
Well, I'm sure that got your investigative juices flowing, didn't it?
Yes.
Because, of course, you knew that Susan Berman was shot in the back of the head with a 9mm gun, right?
That's true, yes.
And a 9mm gun, they're all semi-automatics, aren't they?
9mm, yes.
And so for those jurors who don't know much about guns, a semi-automatic is a gun, a handgun, that ejects the shell after it's been fired, right?
Correct, yes.
Unlike a revolver that does not automatically eject the shell, a handgun that fires a 9mm will eject the shell after it's fired, right?
Yes.
And sure enough, the investigating officers first found an ejected 9mm shell.
Yes, they did.
You were aware from your review of the case that whatever bullet killed Susan Berman, entered the back of her skull, did not exit, right?
Correct.
That means that there were fragments or pieces of the shell still in her skull when they did the autopsy.
Of the projectile, yes.
If I didn't say that, I think I said bullet, but at any rate.
Yeah, bullet. It could bullet projectile was referred to it.
Okay. And it's let me put it this way. It had splintered or fractured so much that there was no way to get ballistics off of the projectile. Is that right?
I believe so. You mean as far as lands and grooves and
Right.
right-hand twist, left-hand twist? Is that what you're talking about?
Yes, and again, for the jurors that don't know what you and I seem to be able to understand, with some recovered bullets, either from a body or someplace, with a recovered bullet, if there is enough substance to it, a ballistics expert can examine that bullet and perhaps match it to a gun, right?
That's true. And if I may explain about lands and grooves.
Yeah, I'll do that.
Okay.
I'll bring it up.
I'll let you do that then.
The lands and grooves are the things that go down a barrel and cause the bullet to spin as it exits the barrel, right?
Correct.
And that gives the bullet more stability and it goes straighter, right?
Exactly. Just like a quarterback throwing a football.
Good.
Causes the spin.
I got that. Great.
There you go. You could use that too.
Thank you. I'll do that next time I get a chance.
Yeah, it's like your poker thing.
Well, did you learn a little bit about what Easy Street is?
To be honest, I already forgot about it.
Okay. So, but in this case, because the bullet had fractured, there was no way of finding lands and grooves.
It's fragmented, not fractured.
Okay, fragmented.
It broke up.
Yeah.
Yes.
Because the lands and grooves in the bullet, in the barrel, will leave marks on the bullet if the bullet's not too damaged.
Correct, yes.
Now that's the ballistics involving the projectile, the bullet itself, the slug, if you will.
Yes.
I want to ask you a moment about ballistics, or the examination of an expended shell. You know, don't you, through your 35 years of experience, if I'm correct about the number, you know that there are ways that ballistics experts can examine a shell and compare it to a gun, if they have the gun, to see if that shell was fired in that gun.
You're talking about the casing?
The casing, yeah.
Yes, yes. Either by using extractor marks or the parts of the weapon that eject the bullet or the casing out, as well as the indentation from the firing pin when the gun is fired.
Because there are enough differences in even the same make of gun that the individual gun may put individual markings on that casing, right?
Correct, yes.
And so I started this by asking you, well, you got your investigative juices flowing when you heard that Mr. Durst was arrested with a 9mm semi-automatic weapon. You came to Galveston and wanted to get that tested as soon as possible, didn't you?
Yes.
And in fact, you got it tested.
At the Pasadena, some firearms guy with Pasadena.
Actually, it was a firearms woman, wasn't it?
No. It's a man, blonde guy, I remember him.
Okay.
Firearms guy, and I don't know if it was the PD, but he was in Pasadena, Texas, is where he was located, out between Galveston and Houston.
In fact, Pasadena is the second largest city in Harris County, isn't it?
I got no idea about Texas.
All right. At any rate, you got the 9mm that he was arrested with and the shell, and you got it compared by a ballistics expert, right?
Yes.
And the result was that gun was not the gun that fired that bullet. There's no evidence that that gun was the gun that fired that bullet.
He wrote it up as inconclusive in Pasadena.
Right. And you've tested it since then, haven't you?
I had Gary Jones fly the gun out here to Los Angeles where we had it tested by our firearms.
By your own people, and it was negative, wasn't it?
Correct, yes.
Okay. So we can rest assured that there's no evidence that Bob Durst's 9mm was the 9mm that killed Susan Berman.
That is, go ahead.
That's unfortunately correct for you, isn't it? Well, let me take the unfortunate. That's correct, isn't it?
Repeat that question again.
Yeah, it was all over the place.
Well, he was.
So that my
something.
statement is correct. There is no evidence that Bob Durst's gun killed Susan Berman.
Right, that gun is not the gun that killed her, yes.
Now there's a couple of other, actually 3 other guns that have been put in evidence here. 2 of them are .38 special revolvers, right?
Correct, yes.
And your information was that those came from Bob's arrest in Pennsylvania.
Yes.
Okay. Now, likewise, because of the caliber and because of the fact that they're revolvers and do not automatically eject a fired shell, those guns are not the guns, or either one of them, that killed Susan Berman.
Correct.
And there's one other gun involved here that's in evidence. It's been shown, a picture of it been shown to the jury. A .22 caliber Ruger, right?
Yes.
Target pistol, right?
Yes, I'm not familiar with 22s that well, so. But it is a 22, yes.
And that was not the gun that killed Susan Berman.
Correct.
Your information is that that was a gun that was found in the search of a trash can behind Bob Durst's apartment in Galveston, Texas, a few days after Morris Black died.
Yes, I believe it was recovered by Sergeant Jones from Galveston PD.
And Sergeant Jones is the detective in Galveston that you met with to take or to see the guns at first.
Sergeant Jones was the one that pretty much processed all that Galveston crime scene, the body parts, the recovery of the weapons in Texas. In my mind, he was the main guy. Although Cody was the detective, I think Sergeant Jones did most of the labor.
Okay. You met with Jones first before Bob Durst was found not guilty while he was waiting for trial, right?
Yes.
And you met with him after Bob Durst was found not guilty.
Correct, right? To take possession of the evidence.
That's when you got the order that allowed you to take possession of it.
Correct, yes.
And you met with Cody Caslis at the same time?
Yes, we met Cody each time we went down to Galveston, yes.
Is it fair to say that they were, and I'm not asking what was said, is it fair to say that both of them were upset by the outcome of the case in Galveston, the fact that Bob Durst was found not guilty?
I'm sure they were. I almost fell out of my chair when I heard it, so I'm sure they were upset. They didn't say anything to me, but I'm sure they were. Okay.
And I assume that you knew that Sergeant Jones in Galveston, when he found the .22 Ruger in the trash can behind Bob Durst's apartment, also found 2 .22 magazines. You know, you aware of that?
Well, I'm trying to remember if they were in the trash can. I mean, I know he recovered them, along with some receipts or something in the trash can. But I don't know if the magazine was in the gun or if they were laying in the trash can. I can't say as I sit here. I'm sure you'll ask Gary that if you get a chance.
Well, you mentioned along with some receipts. There was all kinds of evidence, wasn't there?
All kinds?
Yeah.
I don't.
There was even a receipt to an optometrist,
right,
for some glasses under the name of Bob Durst that he was supposed to pick up in a few days. Right?
Exactly. I think that's what led them to Bob Durst.
Keep your voice up, please.
Oh, I'm sorry. Let me get over here to the mic.
There are also receipts from Chalmers hardware store for purchase of a bow saw.
I believe so, yes.
And other documentary evidence, if we can put it that way, that led straight to Bob Durst.
I believe so, yes.
Now, you're aware also, aren't you, that the magazines, in other words, the clips for the .22 pistol were found at the same time, whether they're in it or out of it, doesn't matter.
Yes.
In fact, earlier before lunch, part of what you were asked about were the 2 magazines. I don't recall whether they were marked. I don't believe they were they? Okay. Okay. Mr. Jones will be testifying either in person or by stipulation. At any rate, the other thing you're aware of is that one of the magazines was filled to capacity and the other magazine had 1 less bullet in it. Isn't that right?
I don't recall. I know there was some ammo that I brought back. I don't remember.
Well, I'm talking
it had
about
already been packaged and separated from the magazines by Gary.
Right.
I don't remember seeing them in the magazines.
Well, I'll clarify my question. Not whether you saw them in the magazine, but when they were found by Detective Jones, weren't you aware that when he found those magazines, one had was filled to capacity and the other one had 1 less bullet than capacity?
I don't.
Assumes facts not in evidence and calls for speculation and irrelevant with respect to this witness. If I may, Your Honor, I can also
Just a moment. So you're all into this witness. It's not. The question is whether it's relevant. Okay. So foundation. I'll sustain lack of foundation.
Your Honor, may we?
Well-
I sustain lack of foundation.
Was that, Your Honor, I was simply asking, may we approach on this issue so that I have not objected on the 20 questions about Galveston, and I want to educate the court as to some information that the court might not know in terms of what's coming regarding a 352 objection. I can't do it without a speaking objection.
Well, say 352 and that comes up. I sustain the foundation objection, so lay a foundation, Mr. DeGuerin.
Well, I'm asking about the information that the detective had and about these guns that have been introduced through him. And
Ask him what he knows and how he knows it.
well, okay.
Before you elicit the question, there must be, the foundation is that he has a basis for knowledge of this fact.
What you know from your visit to Galveston and eventually recovering and bringing here these guns is that the .22 caliber magazines were recovered, with one having filled to capacity and the other one having one less bullet.
352 assumes facts not in evidence.
They will be in evidence,
It
Judge.
does lack foundation. Sustain.
Your Honor, may we
Well-
approach, since these questions are all in the general areas,
No.
that I can explain.
We've stipulated to what Gary Jones is going to say, and that's
The
part of what he's
problem
going
is
to
that-
say.
All right, stop. Approach, fine. You're gonna interrupt anyway, I guess.
You want this on the record?
No, I'll find out for you. take a quick bathroom break. We'll give the jurors 5 minutes. I should have done it before we went to the side. So do not, let's come back in, so just like a five-minute break. Maybe it might take 10, I don't know. So do not converse among yourselves with anyone else on any subject connected with the case. Do not form or express any opinion in the case. We'll see you back in 10 minutes. So left the courtroom, a couple of issues. One is, well, an inquiry is, so I think you heard, Mr. Lewin, I think you heard me talk with the juror who has an appointment on July 12th. So is that a impossible burden for you to do a half day on the 12th?
No.
We'll accommodate the witness, and that gives, in case the interview facilities are better here for the defense to talk to Mr. Durst, that gives them another 4 or 5 hours with him. So I'll let her know she can do that. Second thing is...
Yeah, what time would we leave that day? I just need
Is
to
that
mark it.
July what?
What time would we leave on?
Well, we'll go through 12. Well, she says she needs to leave at 1:45, so what good is that?
Till noon. Okay, I just wasn't sure
Yeah,
what the
so we'll
time.
go till noon.
Till noon, half day.
We'll go till noon.
July which?
12.
12.
Yes, July 12th. The next, is there an updated estimate as to when the trial will be over? Which means to me that you must be boring one of the jurors if they want to know. I mean, they want to know when it's over, they can't get enough of it, they can get enough of it. All right, so juror number 14. So you believe right now that you're going to finish the People's case in July?
Well, we believe, the People's case,
Yeah, People's case.
we believe we will finish by the end of July, and maybe sooner than that. It just depends. It's very hard.
But our estimate right now is the end of July.
Yes.
And then the defense, I know of, well,
Three
how
witnesses.
3, it sounds like 2 though.
Well, it sounds like there was 3, now there's 2, but it sounds like they're going to replace potentially Dr. Ouchu. That's my
We
understanding.
don't know that yet, Your Honor. We'll announce it as soon as we do know that.
So that's about it. So do you estimate that's 2 weeks, 1 week, 2 weeks?
Well,
I know cross-examination is, imagine it being substantial.
I think
So-
2 weeks is a safe estimate.
Okay, so then, we think mid-August.
Yeah, I would say I think their case is more likely, from what I know about it, given the cross, 3 weeks, but I don't know for sure.
So we should be done by the end, and deliberation, argument, the defense is gonna need a couple of days, Mr. Lewin, you'll be a couple of weeks, so that'll be,
I'm sorry, I give up.
I don't want to, that was a mean comment, Your Honor. That just snuck
I
out.
saw a 5-day closing one time that was really
Well-
excellent. It's the what shall I say, the Fidel Castro style of,
Yes.
of persuasion. It's where you just vent, just going on. The speeches are listen. You did a great opening.
Your Honor, you'll be happy to know,
Yeah.
I hate
Yeah.
spoiling it, but you'll
Yeah.
be happy to know, the closing argument, I'll be doing rebuttal. Mr. Balian will be doing the closing. I'll do rebuttal.
Okay, you understand that rebuttal is limited to responding to the people's argument.
I do, and I'll be ready to respond to whatever they come up with.
And it's not limited in time. It could be longer
Yes.
than the people's argument, for sure.
Here's what I can tell you, I'll respond to every point they make.
And Your Honor, we're hoping to do what we did in the beginning, which is to share, if the court will permit us
To share.
the closing.
Thank you. So I'm going to tell the jurors that expect to be here through August.
Yeah, I think that's probably accurate, Your Honor.
Well,
Goodbye, Mr. Ray. Take care.
Thank you.
See you later.
So let's see.
Your Honor,
Yes.
we are still in session, which it sounds like we would be. Is it possible it could be dark on August 18th?
Will the defense object to that?
If Mr. Bailey needs it, it's fine with us.
Can we have the opening of dove season off?
Okay.
What day is that, Mr.?
It's usually the Labor Day weekend.
Yeah, you got that off.
You
Sorry
better
for the
make sure
ducks.
you're hunting in Texas. I don't know if that'll work here.
Depends on what you're hunting.
I don't know, is duck season different in Texas from California's duck season?
I said doves, not
Doves.
ducks.
Doves?
Doves.
Doves,
There's-
D-O-V-E.
There's
You
very,
kill little doves?
You hunt doves?
What kind of guy are you?
Where'd that come from?
That's our witness.
Man, I can't believe you're killing little doves.
No, big doves.
What did they do to you?
Okay.
To answer Mr. DeGuerin.
We don't have a dove season
John, to
here.
answer Mr. DeGuerin's question, apparently
there is a
spotted dove and ringed turtle dove, as long as there's mourning dove and white-winged dove, can be shot and killed September 1st.
This poor court
14th,
reporter is actually
and
taking.
November 13th through December 27th. It's only a couple of weeks each time, Dick.
Where, here?
All throughout the state.
Yeah, well, I'm gonna hunt back in Texas.
This is yeah, this need not
Do
be on
you
the
eat
record.
doves?
I
Yes,
do.
they're delicious.
Yeah.
Are they like little squibs or squabs or whatever they call
No,
those
no,
things?
not the big doves we have.
Mr. Durst is here with his lawyers. People are represented. I'll also let you know that we are going to have a half day on July 12th. We'll be here morning only on July 12th. And there was an inquiry about our progress. It's good. You should expect to be here through August, okay, on the trial. But we may do. I can't say when in August we'll finish for sure, but we should finish it during August. So plan to be here in August, but we should finish sometime in August. All right, Mr. DeGuerin, you may resume your examination of the witness.
Thank you, Detective Coulter. Just so we're clear about the status of the guns, and particularly the .22, you do not know of your own knowledge, personally, what the status of the guns were. No, let's leave it on the .22. The .22 are the magazines when they were found by Detective Jones, right?
No, I was not there.
Okay. Anything you know about that would be hearsay.
Yes.
Okay. What you do know, though, is how a semi-automatic functions as opposed to a revolver.
Yes.
In a semi-automatic, there's several models, of course, and several designs. The one that's involved here is People's Exhibit 163. It's a Ruger .22 with a heavy barrel as like a target pistol, right?
Right.
It's a little different from, say, the Browning high-power 9mm in the way that it has a plunger as opposed to the whole top of it sliding, right?
Correct, yes.
What was your preferred weapon when you were
Well,
detective?
for the first 23 years, I carried the 6-shot revolver they gave me in the academy. And then after the North Hollywood shootout, I thought I needed something a little bigger, so I got a 45.
Model 1911 Colt?
No, I had a Smith.
A Smith & Wesson? Okay, but Smith & Wesson,
Right.
model 1911 Colt, Browning, they have a slide to eject that comes back, the whole part of it comes back, right?
Correct, yes.
Whereas this 22 Ruger has a kind of like a plunger that comes back to eject and put the new shell in, right?
Right.
Now, if you were to grab the gun and have your hand over where it ejects the shell and it's shot and it comes back, it could pinch your finger, couldn't it?
Exceed scope of direct attempt.
Well, just like this.
I'll allow it.
I've never fired a 22 target pistol, so I don't think I'd be putting my fingers near it.
Okay. Well, did you see how I was able to stop that accidentally, really, with the web of my thumb
Here
and
is
forefinger?
testifying, it's an improper question. It's also irrelevant, it's 352, it lacks foundation, assumes facts not in evidence.
Overruled.
Did you see that?
All of them?
You better repeat that question again. I got lots of
Well, okay,
objections.
I'll probably draw the same objection, but I'll repeat it now that the judge has allowed it. You see how, maybe I better, it would help if we could take this plastic thing out here, Judge. Can we do that?
No.
No.
Okay. You see how, when I pull that back, it pinches my thumb right here? The skin between my thumb and my forefinger?
Okay, if you're saying that, it's your thumb.
And then when I pull it out, you see that?
I couldn't see it from that far.
I mean, yeah.
Yes. Okay, Mr. DeGuerin, come on up.
You gonna do it again?
Yeah.
That was like
I'm
pain.
gonna have a blood blister on my
I'm
thumb.
gonna ask you to do it about 6 times.
Oh, well, you can.
See how many times I can get you to do it.
You shouldn't be saying that. That's cruel.
Well, if you're gonna keep doing it.
I'm gonna do it one more time.
What, you let go?
Of course I did. My
You
finger
got
was
smart that time.
Well, my finger was getting pinched. That's why I let it go.
I don't know what that was supposed to prove, but okay.
Objection held at this point, Your Honor.
No, overruled.
Have you seen the picture of Bob Durst 10 days after he was arrested and the blood
Last
blister?
foundation assumes facts not in evidence. This exceeds the scope of cross-examination, calls for an improper expert opinion.
Overruled. Have you seen it or not?
No.
Okay.
That'll do it. Okay.
Thank you.
One further set of questions about guns and calibers. It's true, isn't it?
May I return the gun to the envelope?
I suppose you can. I'm through with it, if that's what you want.
Thank you.
Your Honor, just to the court take
Most-
notice, Mr. Bailey did not point the weapon at anybody in placing it back in the...
Yes, Mr. Bailey is careful. Thank you, Mr. Bailey. Appreciate it.
I think I was pretty careful with it, too.
Mr. DeGuerin was careful. Thank you. Appreciate it.
So, before we get away from that, you know that of all the calibers for either rifle or pistols, but let's stay with pistols, handguns, of all the calibers, the 2 most common calibers in the world are 9mm and 22. That's a true statement, isn't it?
I could only talk from my experience in all the shootings that I've handled, that yes, 9mm is the most common. 22, not so much. Revolvers, I saw a lot.
And of course, I don't mean.
Question?
Well,
That's my experience. I can't speak for the whole world.
well, your experiences with murder cases, and I understand that, but I'm talking about overall, whether it's guns used in crime or guns that are on the market and easily purchased. From all that you know, the 9mm and the .22 are the two most common calibers in the world, aren't they?
I could speak as far as 9mm are common, yes.
Okay.
22s I can't speak for.
Now, you asked that the guns be traced through the ATF, didn't you?
That's correct, yes.
And it's true that all four of the guns that you brought here were bought by Bob Durst under his own name from gun stores.
I believe they were, yes.
And that gets me to another issue about Bob Durst using his own name. The travel records that you found were all Bob Durst using his own name, weren't they?
Yes.
The bank records that you either yourself or through your investigation found, Bob Durst used his own name, didn't he?
Yes.
The telephone records that you found, Bob Durst used his own name, didn't he?
Yes.
You've testified here about some calls from Garberville to San Francisco on December the 20th, I believe, are the ones that you testified about, but you got other records that showed other calls being made by Mr. Durst from Northern California to San Francisco, didn't you?
Are you talking about off that calling card? Or
Sure.
off of his cell phones?
Both.
Or what? I'd have to look at all these records. There were hundreds of calls, and I can't remember each one, what they were. So if you got something specific, and you have it, let me look at it.
Yes. Among the calls that you researched, I assume that you asked to identify some of the numbers at least, right?
There were some of the calls that were made off of the airphone. I attempted to identify who he was calling. I think, I want to say one or two of the numbers was an attorney, if I remember right. The numbers from Garberville, I think it was, he was just checking his messages. Now that I think of it, he was calling for his messages.
I want to ask you if in researching the numbers called by Mr. Durst, you found that the San Francisco number that he was calling was to an architect by the name of Mike Yoshida. Does that ring a bell?
It doesn't ring a bell, but it could have been, yes.
Okay.
I mean, 20 years later, I can't remember their name.
I'm sure that's why you've got your notes there in front of you, and I understand the passage of time as it plays tricks on our memory.
Right.
But does that name sound familiar to you at all? Mike Yoshida, an architect in San Francisco who was working on a project for Mr. Durst during that time.
Not as I sit here today, it doesn't ring a bell, but it could have been.
Well, you did know from your investigation that Bob Durst was expected to be in Los Angeles to visit with Susan Berman for during the Christmas holidays of 2000, right?
Question's improper.
Overruled.
Your Honor, the question is calling for a conclusion. He can say what witnesses have told him, not what actually occurred, etc. The question is calling for a conclusion for the detective to say what actually occurred.
I didn't say that wasn't the question.
That's why
The question was he was expected. A lot of people. Let me rephrase the question.
Overruled. Yeah.
Yeah, a lot of people told you that Bob Durst was expected to be visiting Susan Berman during the Christmas holidays, right?
Yes, that he was coming down to visit for the
I mean, it was no secret, was it?
No, not among her friends, no. Some of her friends, not all of them.
Now, and I'm not trying to be repetitious here, but the particular flight to San Francisco from JFK, I believe, on December the 19th that you've identified, that was Bob Durst flying to, or the ticket was in Bob Durst's name, flying to San Francisco on December the 19th.
Right, United Airlines flight number 5, I think it was.
Well, now, it's been 20 years. You remember that?
Well, I testified to it earlier.
Okay. And you also found that there was a flight from San Francisco, a little puddle jumper up to further northern California?
Yeah, Arcadia has a small airport. I think that you could do a puddle jumper from San Francisco to Arcata, which is just outside of Trinidad, Eureka.
Right.
Kind of in between.
And you...
Oh, I'm sorry.
You developed evidence that when he landed in San Francisco, he then took the commuter or puddle jumper flight to Northern California.
I didn't find an airline that he took up there, but I did find a cab driver that picked him up at the airport to pick up his Explorer at the Ford dealership place. So.
Right.
I don't know what airline goes up there. I don't know.
Okay. Well, let's talk about that Ford Explorer. That Ford Explorer was, as far as you could determine, kept in Northern California, right?
Yes.
And at some point, detectives found that Ford Explorer, correct?
It had been sold to a gentleman in San Francisco, I believe.
Did you do any forensics on that Ford Explorer to see if you could find anything, even though it had been a passage of time, but did you do any forensics?
Forensics, no. I think we checked mileage from when it was transferred to the new buyer from the time it was last serviced in the dealership in Arcata.
Right. Okay. Now, you mentioned that, in fact, you and I met for the first time in Galveston when you brought your forensic handwriting expert to take samples from Mr. Durst.
The handwriting
Right.
exemplars, yes.
Now, up until that time, the handwriting on the cadaver note and the envelope, that same expert had identified as being Niall Brenner's, right?
Your Honor, that is an improper question. This goes to the court's prior ruling. Please instruct Mr. DeGuerin and the jury, Your Honor.
I'm tempted not to with your, the way you're phrasing it, but I will sustain the objection. And
Your Honor, could the court, Mr. DeGuerin knows...
Wait a minute. Hold on. That's not correct.
This
They
is
brought
not-
they brought up the handwriting expert. They brought up
Your
the
Honor,
person.
Court's ruled on this.
Yeah, I
We've
did.
had
I did.
repeated motions, and they just do what they want.
Mr. Lewin, you seem to do what you want. The objection sustained.
Forget Niall Brenner. That same handwriting expert had identified somebody else as being involved.
Relevance.
Sustained. Hold those questions, and I will address that at a 4:02 during the break, okay? You may proceed to a different subject.
Okay. Telephone records. You've introduced several telephone records, and including the cell phone, a cell phone that had been used by Mr. Durst up until November the 14th, I believe you said. Is that right?
Correct, yes.
And did your records ever show that Mr. Durst ever used that cell phone again after December 14th?
No.
Were you aware that Mr. Durst went to Galveston under an assumed name and rented a cheap apartment dressed as a mute woman?
Not till I heard from Cody Caslis in October. We didn't know where he was.
Right. So, were you aware that November 14th is about the time that he went to Galveston?
I'm sorry?
November the 14th, 2000, when the use of his cell phone stopped. Were you aware that that's coincides with when he went to Galveston?
No, I'm not.
Okay. One of the other things that was introduced in your testimony was a notebook. It's Petitioner's Exhibit 167, which is an envelope that contains a notebook that had some contents, right?
Had some contents?
Yes. One of the things that was pointed out to you was a note that was in the notebook.
There is a note and some writings, yes, on the first few pages.
Right, but there were other contents of the notebook, right?
Contents?
Yes. In the same evidence.
In the notebook, I don't recall anything else. There was some writing.
Contents of Meade notebook.
Oh, okay, what is it? Can I see it to refresh my recollection?
May I approach?
I can't read that part.
He's pulled a separate envelope outside of the larger envelope.
Yes.
I'm going to open the envelope and take a peek in here and see. There's There's some photos, some notes for, well, actually, it looks like that same note, the Women's Center, a copy of it. I don't know whose writing this is in red, some photos of a dog.
Yeah, there's some folded pieces of paper that contain some photos.
Okay.
And I'm not so concerned about the writing on the outside of those papers. They appear to be simply containers for the photos. Is that a fair statement?
Yes, yes.
Okay. And,
Can we have one more?
sure.
Yeah.
Yeah. I have a stipulation offer.
All right.
That Detective George Shamlian from the Los Angeles Police Department removed the contents from the Meade notebook and placed them in this envelope he's now discussing. He took them out of the envelope and examined them. So those were removed from the Meade 5-star notebook, those loose pieces of paper and photos, by Detective Shamlian and placed in that separate envelope.
They were all contents of the Meade envelope.
Correct.
Except perhaps some of these pieces of paper that are folded over.
Yeah, the piece of paper folded up is Detective Shamlian's way of packaging things.
I was going to say I didn't recognize the writing.
All right.
So stipulated?
Stipulated.
All right, court accept your stipulation.
And that they're all part,
They were all contained in that Meade 5-star notebook.
all part of Petitioner's Exhibit, I'm sorry, People's Exhibit 167.
Okay. I'm going to put it all back in this manila envelope.
Actually, leave it out because I'm doing it.
Okay, there you go.
And what, may I offer one more part of the stipulation?
Yes.
The Women's Center, you said there was a photocopy of it in there?
Yeah.
Stipulation would be that Detective Shamlian made a photocopy of it and put it in the envelope because he left the original note in my Meade 5-star. So that photocopy wasn't in there when it was originally recovered. Detective Shamlian made that photocopy.
Exactly, sure.
So stipulated?
So it's stipulated.
All right, that's stipulated.
Shamlian, Shamlyan.
What I want to do is go over the rest of what was in the Meade notebook. And your understanding, I believe, is that the Meade notebook was recovered when Mr. Durst was arrested in Pennsylvania when he was on the run from Galveston, right?
Right, by Sergeant Jones, Gary Jones. To my belief, yes.
But at any rate, that's where the notebook came. It was something that he had with him in Pennsylvania when he was arrested in Pennsylvania, Mr. Durst.
Yes.
Okay. Yeah, I'm hearing that it's in his car when he was arrested, along with the guns, 2 guns. I'm going to put on the screen here for you to look at it. This was in the Meade envelope. It appears to be a Staybridge Suites, Allentown, Pennsylvania. Receipt from a hotel or motel in Allentown. Is that right?
Yes.
And the date on it is November the 18th, 01 to November the 30th, 01.
Right.
Is that during the time that Mr. Durst was on the lam, so to speak, from Galveston?
He was a fugitive at that time, yes.
Okay. There's also a couple of documents from some statement of account, Fleet, I don't know what that is, but it has a name on it, Emilio Vignoni, if I'm pronouncing that correctly. Emilio Vignoni. You see that?
Yes.
Were you aware that that had been an employee of Mr. Durst years earlier?
I think that is somebody he had contracted with.
Okay.
Yes.
And there's an envelope with a stamp, just a plain white envelope with a stamp and a couple of stamps. I assume that you compared that envelope and those stamps with the cadaver note and envelope, didn't you?
Are you assuming that?
I am assuming that. Is that true?
No.
So y'all didn't see whether that...
No, these are self-sticking stamps. I think I did look at them to see if they were the same 34, whatever the picture is on them. And I don't recall if they matched up or not.
In fact, the stamp on the envelope that carried the cadaver note had an American flag on it. It was a completely different stamp, right?
I believe so, now that you mention it, yes.
Okay. What about the envelope itself? Did you see whether it compared or not?
Just a generic white envelope, about the same. Well, let me look at it in person here.
All right, sure.
Yeah, it's about the same size. It looks about the same size for me.
You need to see it?
No, I saw it when you picked it up. It looks about the same size.
Also in Mr. Durst's possession when he was arrested is a picture. Do you know that to be a picture of his father?
I got no idea who that is.
All right. And a note saying Dr. Ike Hirschkopf. Do you know the significance of that, if any? With an address in New York, East 37th?
No, don't know who that is.
Have you ever, in your detective days, have you ever heard the term pocket litter?
Nope, can't say that I have.
Where someone, either a body you find has litter in its pocket that might give clues to who's responsible?
There have been times, yeah, you find papers and maybe IDs, receipts, things like that. Is that what you're referring to?
Sure.
Pocket litter?
Yeah,
The
that's...
scraps of paper and stuff?
Sure.
Yeah, I've seen that.
And
sure.
in fact, sometimes when you arrest somebody and they have in their pocket pocket litter that might be a clue.
Sometimes they find all kinds of stuff in their pockets.
Yeah. All right. And there seems to be an article of several pages. It's torn out of a book, and the title of the article is "The Impact of Growing Up with ADD." See that?
Yes.
And it's got several passages outlined in green ink. You see that?
Yes.
From all you've known about Bob Durst and learned about Bob Durst, he had kind of a thing about writing in green ink, didn't he?
A lot of the writings that we found were green ink, yes.
Okay. And then just a few more things here from that notebook. This is a picture he was carrying around with him. Do you know who those people are?
No clue.
Would you be surprised if that's a much younger Bob Durst and Kathy Durst?
If you say so, I don't know.
Here's a copy of one that that's in evidence elsewhere. Let me show it to you. If I tell you that's a picture of Bob Durst and Kathy Durst and their dog Igor on her wedding day, their wedding day.
I can't speak for the dog, but yes, I do recognize Bob Durst and Kathy Durst in this photo, yes.
Okay.
We'll stipulate it's Igor.
So stipulated.
Court accept that stipulation, Your Honor?
Yes, I guess that's Igor.
Good old Igor.
Finally.
Just a couple of others. I don't think you will recognize him, but I think there's no question that that's Bob Durst at about the age of 9 or 10.
Mr. Chairman, the witness can't stipulate. We will stipulate. If you ask, we'll stipulate that's Bob Durst. We don't know the age, but this witness can't talk about childhood photos.
Well, what you can talk about is, you know, that these photos were all in Bob Durst's possession when he was on the lam.
That's going to call
Right.
for hearsay, the same issue we talked about in sidebar.
These things were in the, witnesses testified that that he learned that this notebook was in the possession of Mr. Durst in his vehicle when he was arrested in Pennsylvania.
Your Honor, people will stipulate that those materials were in the vehicle when Mr. Durst was arrested. We'll stipulate it. Doesn't have to ask this
And then
witness.
why did you object earlier?
Okay, so that's that's fine. The court will accept the stipulation. You can still display them to the witness. After all, he testified on direct to their existence, so I think it's proper for you to inventory them with him. And the
Notebook and evidence?
is the notebook in evidence? Yes, it is.
Yes.
Okay.
And we have a stipulation coming up for the officer who recovered it.
That's fine. I mean, you introduced it through this witness, so he can go through it with the
Yeah,
witness.
for sure.
It's fine.
We would interject the 352 for this witness, Your Honor, given what the court's been made aware of. With respect to undue consumption of time, given
Auto
the
roll.
stipulations. All right?
And finally, that's not everything that's in here, but this is finally one I'm going to put up here. It's a receipt. Actually, it's an envelope that looks like a receipt from a Rent-A-Wreck in Mobile, Alabama. Right? If I described that correctly?
Oh, yeah, I didn't know if you were telling me or asking. Yes,
Well, I'm
yes.
telling you and asking you
Yes,
to.
it is.
Okay. There's nothing in it. If you want to take that break now.
I
we
will.
can-
So we'll take another break, but we'll come back at a little bit shorter, actually no, we need about 5 more minutes. So 3:20 p.m., we'll break until that time. And do not converse among yourselves or with anyone else on any subject connected with this case. Do not form or express any opinion on the case. All right, our jurors have left the courtroom. I'd like to talk with all of you about the handwriting evidence. So we had, of course, to recap, hearings on the admissibility of handwriting evidence, handwriting comparisons. It was a full-on Sargon hearing. I received an enormous amount of briefing and literature on handwriting. I was about to rule. I think I did rule that it was going to be admissible. The defense then stipulated to the handwriting, or at least stipulated to the Mr. Durst's authorship of the so-called cadaver note. And so I was a little surprised when I heard about handwriting evidence, but then I realized it was being presented to show evasiveness, a consciousness of guilt at the time Mr. Durst is asked to provide an exemplar. So I think that's fair game. I don't have a problem with that. But then we have cross-examination. The cross-examination was, isn't it true that a handwriting expert identified another person? Now, here's the problem. So there's been I did say at the time of the hearing that while I was admitting the handwriting evidence, that didn't mean that the defense couldn't cross-examine on cross-examine on the point. In other words, I wasn't finding, as a matter of finding the fact that it was his handwriting. On the other hand, then the defense stipulated essentially to that. Also, as far as these, what I've called the red herring evidence, these third-party culpability type of arguments that I've excluded, this identification of Niall Brenner isn't relevant for the purpose of identifying him as a suspect. Perhaps it could be admitted to reduce the credibility of a conclusion of a handwriting expert, but that doesn't seem to be an issue any longer since there's been a stipulation. So what did you have in mind, Mr. DeGuerin, in asking a question like that?
Yes, sir. I wasn't asking it in order to raise what I still believe is a valid point about Niall Brenner, but I know that you've ruled on that being a suspect. What I wanted to do was show that after this person first identified it, Niall Brenner, then she identified Mr. Durst and said that she had been wrong about Niall Brenner, and that kind of shows the ephemeral nature of handwriting.
Right, but handwriting evidence is not introduced to prove his guilt here unless it's being offered to prove his authorship of some other document. Mr. Chestnut?
Yeah, Your Honor, the real focus on this is that part of the theme that we've already developed, their investigation has not been what we would consider up to par. So now we have a situation where they went to all this trouble to go to Galveston and take his handwriting. We've had elicited that he was evasive, and meanwhile, in the course of their investigation, their own experts said it wasn't him. That we should be allowed to do.
No, because so let's just narrow it down.
Wait,
I'll hear from you if I need to. Okay?
Well, Your Honor, I need to let the court know the court's ruled. I have the page, the quote, etc. They're missing the main issue, which is sought.
Can you hold your tongue for
Sure.
like a minute?
Sure.
Okay, so a rhetorical theme is welcome. It can make for a persuasive speech. However, it is not by itself a determinant of relevance. Your theme must be derived from the relevant evidence, and this does not appear to be relevant. If it is what you're describing is that there's an error in handwriting identification. Handwriting identification is no longer an issue here, as far as I know.
But Your Honor, it goes to the whole question of the thoroughness and accuracy of the evidence that they do have. And in a circumstantial case, which is what this is, the failures of investigation are not more than, they're more than a theme, Your Honor. They go to the question of whether or not there is proof beyond a reasonable doubt.
I think it's more a confession case with corroboration,
Yeah.
but with circumstantial corroboration. I see it more that way, but anyway, okay, now we'll hear from Mr. Lewin.
So, Your Honor, number one, the defense, from the beginning of this case, did not want to say whether Mr. Durst wrote the stuff or didn't. However, they litigated for 5 years saying he did not write it. Mr. Chesnoff, in fact, stood up in court and said Mr. Durst did not write the cadaver note. We had hearing after hearing after hearing. Now, here's what's important. The court under Sargon, not only did the court rule explicitly that Niall Brenner, the handwriting stuff, could not commit a third-party culpability, the court said the following. This is from July 17, 2018. At page 42, line 1, this is the court. Now, testimony regarding William Lever, reviewed by Karen Chirady, and that is all of the Niall Brenner, Bob Durst comparisons by LAPD, quote, these are clearly, to me, inadmissible.
And the reason, thank you for the reminder. The reason it was inadmissible is because of Sargon. In other words, you're trying to raise this scientific, this examination to, but it's not. But
if I can finish,
there might be an alternate theory.
Your Honor, there isn't. The court has. Here's what's going on, Your Honor. You've ruled on this 3 different times. You told them. So what happened was they lost the Sargon. They lost.
Lose the Sargon.
Let me finish.
That is completely
you lost
inaccurate.
Yes, you lost the Sargon.
No, we didn't.
Okay, stop for a second.
So, Your Honor, so what occurred is, if I can finish, is that the defense attempted to put on this handwriting evidence. The court said it did not meet, not only did it not meet the third-party culpability issue, you couldn't even put it on because it violated Sargon. The defense at that time said, well, no, Your Honor, we want to bring it in for another purpose. We want to bring it in for the exact purpose that they're saying today. So now what they've done is you told them they couldn't do it. So now in the middle of this, with no hearing, with no new motion filed, with nothing, they try to sneak it in here when you directly told them it cannot come in. Now, it's even more absurd because in the end, let's really look what's going on here.
Right.
They've now admitted their client wrote the cadaver note. So apparently what they want to do is they want to try and put on evidence that the LAPD apparently did a poor job with handwriting when in the end their client is now saying it's their 4th different
So here's my
defense
question to you. Are you trying to prove that any other document was authored by Mr. Durst on account of handwriting?
No, they have stipulated to every document that we have.
So I'm glad that Mr. Lewin reminded me, because it had escaped me for a moment, the part about the Sargon aspect. In other words, this evidence does not implicate Niall Brenner. Now, I think you're trying to suggest perhaps that to the extent you're saying that it also proves that an investigation was inadequate or that handwriting comparisons aren't probative, I think 352 then keeps it out because that's not much. That's not too probative, and it is quite. I think it's prejudicial because of its implication that has been excluded.
So, Your Honor, the court thinks it's okay for them to bring out the fact that there was an examination and one person who's not truly qualified, no disrespect meant to the witness, tells the jury that he was evasive in this process, and we can't talk about the fact that the process was shown to be flawed.
Right,
by us,
right, that's right. But you're describing it. You're not describing it correctly, because this witness is rendering an opinion as to his evasiveness, the manner in which he's acting when he's writing. He's not discerning evasion from the writing itself. He's not using some graphological method. He's certainly obviously subject to cross-examination on that point. The cross-examination on that point is fine, but that cross-examination cannot be that an expert later disproved identified Niall Brenner's writing. You can't do that. We already had the hearing on that. It's not relevant, and it's more prejudicial than probative.
Your Honor, we would ask just going forward, if the defense intends to go directly against your rulings and do stuff in front of the jury, they need to give notice, file a motion. This is not acceptable.
So when Mr. Lewin decides not to give speaking objections, not to talk over you, not to talk over me, we can maybe have some discussion about that.
Well, no, I think that this is you're reminding me of warring countries with unrelated gripes against each other. I have a different. I'm going to talk to you, Mr. Lewin, about your. It does bother me the way you're going about it. I understand why this particular line of questions bothered you, but you know, at the end of the day, I can tell jurors to disregard it, and they will, and it matters. But for you to behave like you're the way you are, when I tell you not to make speaking objections and you continue to do so, is disturbing. The defense, they don't. You know, it's not just that it's contrary to what I've told you repeatedly that you cannot do. It's also, I think, to some extent, it gives both sides have done it, and it's a way to grandstand in front of the jury, and I don't like it. It's a way for you not only to make an objection to me, but to suggest to the jury that the other side is doing something that is wrong, which may well be, but it's
That's why I asked to
not the jury's business. You know, a quiet objection is that I can hear.
You know, that's why I asked to approach.
Well, because I don't let you approach is no excuse for you to go around it and make a speaking objection. I don't let you approach because I want to encourage you to anticipate these things, to do them in advance and not take
Your Honor, I've
the juror's
litigated every
time.
issue 6 times. How can I anticipate? What happens is we litigate, you rule, they decide they're going to ask whatever they want. So my question to the court is, what am I to do to ethically represent the people in the interest? I brief everything.
Well, here's the thing, because if you make speaking objections, I'm going to overrule them, and your case will suffer. Your case should not suffer. You should not prejudice your case by the form of your objections. If you don't object properly, if I don't have a proper objection, ordinarily I overrule the objection. So the same thing with a speaking objection. That's not proper form either, so I'll overrule it. All right, recess.
Thank you.
Hey, Pete.